everyone, my name is Damilola. You're welcome to Chairman TV. This is a TV where we address different issues in law and also provide solutions to them. I hope you're fully prepared to be enlightened about one of the major topics in law, which is landlord and tenant rights. This is the first part of an exciting series we have for you. In this part, we'll be focusing on tenants' rights. By the end of this video, you would know how to deal with stubborn landlords. If you like what you heard, kindly subscribe to our YouTube channel, Chairman TV, and trust me, you will learn a lot from this channel. You should also like our page, and if you have any questions to ask, kindly ask your questions at the comment section below. Today we have a special personality in our midst. He is one of the most popular property lawyers in Nigeria. He is no other person but Charles Chukwuma Nkwoka. You're welcome to our channel, sir.
Thank you so much.
Sir, I can see you're fully prepared for us.
Well, as you said it.
Okay, that's really fine.
Yes, fine.
Sir, we would like you to address us on the landlord and tenant rights. Majority of us are eager to know about this right, most especially tenants. But before you enlighten us about this right, can you explain to us who a landlord is and who is a tenant?
Okay, thank you so much. Just like most of us know, this landlord and tenant issue is always a very wide issue in Nigeria. Most people always ask one or two questions. So we'll start by defining who is a landlord. A landlord, simply, I will break it down in a very low level so that anybody listening to us now will be able to understand. So I will try as much as possible to avoid being so deep legally. So a landlord is a property owner. A property owner that rents his property out. A proper landlord is someone that owns a property and rents it out to someone for a specific period of time. That's a landlord. The landlord has what they call reversionary interest over the property. You can rent out, you can lease out, but he's still the owner. The ownership still vested on him, but he can give the possession out. So for occupation and use by another person. So that's a landlord, what a landlord is. Then tenant is someone who rented a property, a real property from someone being a landlord. So someone who is in occupation of another person, occupation or possession of another person's property for usage for a specific period of time, usually temporary. So, and the person will surely revert back the property to the person that rented it out or leased it out, being the landlord. So that's just the simple explanation based on the context of this topic.
Thank you very much, sir.
You're welcome.
From your definition, we have the basic idea of who a landlord is and also who a tenant is. So the next question is, do landlords have rights in Nigeria?
Yes, of course. The law called them landlords. So giving them that lord, they are lord over that tenant. So they have their rights. Likewise, the tenants.
Sir, can you give us a brief explanation of those rights? Because we plan to have a part 2 that centers on the rights of a landlord.
Okay. So now when you're talking about rights of a landlord, tenants also have their own rights. The same way they have obligations. So just like we have in Lagos State. In Lagos State, they have the obligations and the obligations of the tenants and obligations of the landlord. So, and knowing that, you will be able to know that when they have obligation, they have rights. And what are the simple rights of a landlord in Nigeria? They have the rights. A landlord has the right to own a property in any part of Nigeria. So then he has the right to receive rent from any person that he wants. He has choice to do that. So he has the right to review his rent. After renting the property out for him, he has the right to review the rent. And also he has the right to have his property maintained and put in a good condition. So because when giving it out, it must be in a good and tenantable condition. And also landlord has the right to evict a tenant in case if there's any breach, or in case if he doesn't want the tenant by any reason or want to use the property for his own personal use. He has the right to do that. So those are the rights of a landlord. And also a landlord has the right to issue a quit notice, and as well as 7 days owner's intention to recover premises. So also landlord has the right for a periodic inspection of the rented apartment with a notice to the tenant. Also, the landlord has the right to restrict the tenant from subletting the property. Sometimes tenants, you give a property, you end up coming back to see the B living in the property. So the landlord has the right to restrict the tenant from subletting the demised property. Also, the landlord has the right to inform the tenant in case of any repair, that if you carry out any repair, I'm going to reimburse you. So landlord has the right to inform any repair. In case even tenants want to repair any property, any of the carry out any substantial repair, you need to consult the landlord and take his approval, obtain his approval before you go further. So landlord has the right to even say no, don't repair my house, leave it like that, I want it like that, or repair it but I'm not going to reimburse you. So you need to take note of that.
Thank you very much, sir. We are fully aware of the right a landlord has over his property. Do you think a tenant also has a right over a landlord's property? I mean, it sounds somehow. He's not the owner of the property. So do you think a tenant has rights over the landlord's property?
Of course, yes. A tenant has his own rights. There's a contract between the parties, landlord and tenant. They have an agreement to be together. It's a relationship. Now, each of them has their own obligation, and when you have your obligation, you have your rights. So tenants have their rights, and if those rights are being infringed upon, the tenant can take action against such a landlord. So they have their own rights. And if I to mention some of these rights, which is very important for tenants to know, whomever that's watching us out there that's a tenant need to actually know exactly what are my rights as a tenant in a property. Because living in someone's house, I paid my rent. I've given something out in consideration to take this property for my personal use and occupation. So I have my rights. You cannot just come there and do anyhow you like. So now, most of these rights are right to receive a receipt of payment. After making payments to a property, you want to rent a property, you have the right to request for the receipt of the payment, and it's an obligation of the landlord to give you that receipt of the payment. And also, you have the right to have the apartment fit for habitation. So the landlord, before landlord will rent a property, he must put that property in a tenantable and habitation condition. So that property must be in a good fit and habitation for you to take it off from the landlord. So it's your right. Also, tenants has the right of peaceful enjoyment of the demised property. The property rented out to them, they have the right. You can't just interfere because you're a landlord. You just barge in, you come in anytime you like, into their, he cannot come inside. Inside that place, what they call the demised premises is a portion, a place rented out to the tenant. He cannot even enter there anyhow any longer. Before you do that, you must give that tenant notice of such entry. Also, the tenant has the right to be issued a valid quit notice. Note that valid quit notice. Some landlords does not want to comply with the provisions of the law. Just like each state has their own tenancy law. Most states, and some states that doesn't have, they have Recovery of Premises Act governing them. Now, for you to have your valid quit notice, each notice has its own duration that is specified by law. So we'll get to know all this things maybe in further discussion on that. Also, the tenant has the right to receive a tenancy agreement. He must give the tenant an agreement stating the terms and conditions of the lease or the rent, as case may be. So you must always give the tenant the tenancy agreement as a landlord. And also the tenant has the right to request for a review of the tenancy. But most cases in practice, tenants they are not always the one to request for the review, because one is that the review is always upward, but there are some instances where review can go downwards, whereby sometimes there may be a road construction whereby we have some cases where they demolish part of the premises leased out by the tenant. So they need to review the tenancy agreement and reduce some certain things. So it's part of the right of a tenant. So right to be reimbursed any payments made in terms of repairs with the consent of the landlord, whereby the landlord requests you to carry out substantial repairs or any repairs in the house which add value to the property, maybe the fittings or the fixtures in the property. So you have the right to request for the reimbursement of those things to cover that. If they don't have them, then maybe on their subsequent rent they can actually put it there. So then the right to renew your rent. You have the right to renew your rent or to pack out after the expiration of the tenancy agreement. So you may decide to pack out for that. So those are the things those are the rights of a tenant in a property.
Thank you very much, sir.
You're welcome.
Sir, you made mention of rights to collect rent as one of the rights of a landlord. There are instances where a landlord collects rent from a tenant and he fails to deliver up possession upon payment of rent. What are the available remedies for the tenant?
Okay, it depends on the circumstances behind the refusal to deliver possession. Now, for instance, if landlords give tenants a go-ahead order to make payment by himself or through his attorney or an agent, then the landlord is bound to give possession of the property, and where he fails to do that, the tenant can request as the remedies to request for the refund of the payments that he made, or sue the landlord for specific performance to give him the property which he paid for, and also to sue for damages, or in combination of that, because the landlord sometimes they will collect money from you, use it and renovate the property. After renovating the property, they will have a better offer, and when they have that better offer, they may not wish to give you that property again, and at that point in time they find it difficult they may end up, even in some cases, they will collect rent from multiple tenants, multiple prospects. They will not give it. So at the end of the day, they may wish to refund the money to whomever they so please. So in a situation like that, you can take action against that landlord for a specific performance to give you that, or better still, just sue for damages because it has deprived you of opportunity. That the time you're supposed to use it to go and look for another property, you held your money down and you refuse to do that. And as well, you can as well charge the landlord, take action for criminal action against the landlord for conversion and stealing. So can take action against it because taking the money from you and they meant to give you that. So, but it depends on the circumstance before you can actually criminalize the matter. But if you take him to police station straight away, police will find a way to assist you to criminalize the matter so that they will have jurisdiction over the matter to entertain that. So there are so many ways, so many things you can do about that.
Thank you very much, sir. Another surprising right of a landlord you made mention of is the right to enter the tenant's apartment periodically. As a tenant, do you mean a landlord can enter my apartment without even giving me a prior notice? And at what time or at what situation can he exercise such right?
Okay, first of all, the landlord does not have the right to enter the premises, the rented apartment, the demised premises without prior notice to the tenant. He cannot. He doesn't have the right. But landlord has the right with a prior notice, adequate notice to the tenant to enter the premises to inspect, to see if there's any damage in the house, if there's anything that needs to be carried out, a repair, or to ensure that the property is still in a tenantable condition. So the landlord has the right to enter, but with a prior notice. So the one that they have right to just barge in, just come in, hey, please there, I want to go and check some. No. They don't have that right, but they have the right. They will give you notice, and those notice must be adequate. It must be either 72 hours, 24 hours, as the case may be, 1 week, it may be 48 hours, depending. But when they give you, if they give you notice and it's not adequate for you, you can actually tell the landlord that this notice is not adequate for me. It's not enough for me to, I'm not going to be available, but on so day, both of you must agree on the date for that inspection. And with that, landlord has the right to enter the demised premises that you have rented apartment or house and carry out some inspections, either by himself or through his assigned or through his agents and attorney.
Thank you very much, sir. So you said I have the right to receive receipts from the landlord as a tenant.
Yes.
In the absence of a printed receipt, what will suffice?
If there's no printed receipt, which is always very important, we will request for tenancy agreement. Tenancy agreement carries a consideration clause where you state it will be stated the amount you paid when the rent is to commence and when it's ending. So the tenancy agreement always makes sure that if you don't have tenancy receipts, make sure you have tenancy agreement. It's very important.
Thank you very much, sir.
Yes.
So we've had some cases whereby a landlord just barging into a tenant's apartment anyhow to seize the tenant's property because he or she fails to fulfill an obligation. Let's say the landlord wants the tenant to pay NEPA bill or waste bill, and then the tenant fails to pay. So in that situation, what do you think the tenant can do?
First of all, it's unlawful for a landlord to barge into a tenant's house. It's unlawful, and having to do that, maybe entering there with force is self-help. It's a criminal offense. And a situation where a landlord barge into the tenant's house, the tenant can actually make a report to the police station, nearest police station of the incident. Then the landlord will be picked up straight away and will be dealt with in law. So he doesn't have the right. He can actually request for the payment of any of the outgoings or usages or whatever case may be. You can request for it, but you either request for it in writing or oral, but you don't barge into the tenant. You can go to the tenant place, knock, and let the tenant receive you. Otherwise, if you barge in there, it's unlawful and you face the law.
Thank you very much, sir. Sir, I have another question for you. In the situation whereby landlords collect rent from we, the tenants, only for us to find out that the apartment is not fit for habitation. For instance, the roof is leaking. As a tenant, what do you think I can do in that instance?
Yes, in some cases, you rent an apartment, rent a house. After renting it and you moving in, you find out that maybe one or two defects in the house might actually render that property not habitable. So in a situation like that, you call the attention of your landlord or the agent, as the case may be, and let them know about that and give them time to repair those things. And it is their obligation to carry out those repairs. It is their obligation. And when they fail to carry out those obligations, they have breached the covenant, one of the sacrosanct covenant of the tenancy agreement, covenant to keep the property in a good and tenantable condition. So you can actually sue the landlord for a specific performance. But please note, when you are thinking of suing your landlord, note that he's a landlord, and one or two things that you know that he can actually evict you. He may come up with something else after the expiration of your tenancy. He may decide to tell you that I want to use this property. My son is coming back from UK. I want to use this property for the tenant, for my own, and we evict you and you start looking for this thing. So first of all, that's why it's good before you rent a property. First of all, inspect that property very well. That's why inspection is very important before you pay for the rent, so that you can be able to identify any defects. Otherwise, some landlord may tell you, they will put on their tenancy agreement renting as is, and what that condition means that they are not carrying out any repair. So you have the obligation to identify any defects in the property, and the way you fail to do that, the responsibility is for you to just bear any consequence that will come out of it. So that's just the thing.
Thank you very much, sir. As a tenant, can a landlord terminate my tenancy at his free will?
No, a landlord cannot on his own terminate the tenancy without a proper notice to quit, or it may be the tenancy has two ways of determination. And when we talk about determination of tenancy, we are talking about that ending of the tenancy. That's it. Whether by mutual agreements like fixed tenancy or by way of quit notice. So by mutual agreement, which is by fixed tenancy, it's always at a fluctuation of time the tenancy will be terminated, and the other way is by quit notice. So landlord does not have the ability to just come up and end the tenancy. The only thing that he must, if he is to do that, to decide to do this, to terminate the tenancy, he must give you the valid quit notice. So landlord must give the tenant a valid quit notice to terminate it. But on the other hand, if you look at it from the free will, you see that the landlord still have that free will. You still exercising free will, because once landlord can wake up, this tenant, I don't like the way this tenant is playing music in my house. I don't like the way this tenant is bringing women into my house. I don't like the way this tenant has been doing this or that and that and that. In fact, I don't want to renew this tenancy. He will stretch you with notice straight away. Is it not at his free will? So you understand. So in situations, some circumstances, we warrant that exercise of free will. So the only thing that the law requires that the landlord must comply with the statutory provision So, and because the tenant is protected by the statute, so and for you to evict a tenant that lawfully take possession of a property, lawful occupation, he must comply with the provisions of the statute. So by issuing the relevant notices, as the case may be, depending on the duration of the rent and the way the tenant enters. So these are the things, but he has free will to decide that I don't want to renew my rent again. I want to terminate this tenancy. But you must comply with the provisions of the law.
Thank you very much, sir. As a tenant, if my landlord serves me a quick notice, what do you think I can do?
Okay. Now, one of the major ways to determine a tenancy is by issuing a quick notice. When a quick notice is being issued out to you as a tenant, now, some people will start dodging to receive the quick notice. No, what you need to do, receive the quick notice, sign acknowledgement for them, put date, ensure that you put date. Now, I will explain so many technicalities involved in this service of quick notice. When you are giving a quick notice, receive it wholeheartedly. Thank you, sir. Take it, write, sign, and put dates there. Now, that will kill the manipulation of backdating. Some technical ways the landlords can manipulate quick notice. They will serve you a quick notice without putting a date there or backdating it. So you put the date of the receipt of that. That's the date, effective date of that quick notice. It's not the date of the letter. So when you receive the quick notice, now what I will advise you, first of all, consult your lawyer. You must have your lawyer, consult your lawyer so that he will guide you on what you need to do. Then you have options. Option to move out or option to argue the quick notice with the landlord legally. So you wait. If you have a counter claim over the landlord, then you may decide not to move out. Stay in the property, wait for the expiration of the tenancy of the quick notice. After the quick notice must have elapsed, the landlord must as well come back to you and serve you 7 days owner's intention to recover premises. Then to recover that possession, he cannot just come after the expiration of that quick notice. He must give you 7 days owner's intention to recover possession. Then you may still decide to wait. Okay, landlord, I'm not going anywhere. This matter will die here. We are not going anywhere. I'm not going anywhere, so I don't have anywhere to go. Then the landlords will go to court and file a claim, eviction claim. Then if you have a arrears to pay, you can also file for arrears, means profit, compensation for use and occupation. There's so many things you can add. You will also sue for damages, so and as well as cost of litigation. So many things that they will join in the claim. So and when they do that, you wait for the court. You go to court and file for your appearance and engage your lawyer to do that. Then you can file your counter claim if you have any. But if you don't have any and you feel that you don't want this court wahala, you just pack out so that there will be no issue. But where you feel that the landlord did not do well, and maybe sometimes there's a defect in the quick notice, because sometimes landlords, most times they don't want to comply with the provisions of the statute. They don't want to give the valid quick notice. Just for instance, in Lagos State, the tenancy law of Lagos State 2011 stated clearly on the section 13 of this law the duration that will be given to a tenant. If you're a yearly tenant, a monthly tenant, weekly tenant, half-yearly tenant, there's specific period of time that landlord. Now, as a yearly tenant, you are meant to be given a 6 months notice to quit. And that 6 months notice to quit must not be less than any day. It must be 6 clear calendar months, and that's where most people make mistake. And once you make mistake and it's short with less 1 day, is invalid. So you can actually raise a preliminary objection in court for invalid quit notice. The landlord will go back and start afresh to serve you a valid quit notice. And where they make mistake, this quit notice, there's technicalities involved in that. And the way the law counts duration is different from the way laymen count. We just count our duration maybe. Like for instance, we are given a quit notice from the 15th of June. Then you now count you now start counting from 15th of June to 15th of June, July, August, September, October, November, December. You now count 15th or 14th of June. That's not correct. If you are given a quit notice, once the month is less a day, you count from the next month. This is very technical. A lot of people don't know about it, and that's where they make mistake. So some stubborn tenants can wait for landlord, and once they notice any defects in the tenant in the quit notice, that quit notice is invalid. They will just wait because the law stated valid quit notice, and valid quit notice, the statute provided things that make it to be valid. So things that will invalidate that quit notice is stated as well. So now for you to do that, they will just wait for you. Just once as a tenant, look at all these things. Engage your lawyer because you might not know it. We have lawyers that specialize in property law, even tenant and landlord relationship. So engage a lawyer, and the lawyer will guide you so that you will not make mistake and end up the landlord will get judgment against you and levy execution or and confiscate your property and levy execution on your property. So those are the things.
Thank you so much, Mr. Charles, for taking out of your time to enlighten us on the Landlord and Tenant Right Part 1.
It's a pleasure.
We hope to see more of you on our program. Dear viewers, home and abroad, I hope you've learned one thing or the other from our YouTube program on how to deal with a stubborn landlord. Don't forget to like our YouTube channel and also subscribe to our channel. If you have any question, kindly drop it at the comment section. Watch out for another segment on how to deal with a stubborn tenant. I know majority of us will feel so excited to hear that there are actually ways in which you can deal with a stubborn landlord. But the question is, are you a stubborn tenant? Of course, not every tenant will agree to that. So, if you are a landlord or a landlord to be, gather here. Let us discuss how we can tackle this stubborn tenant in our next video. I remain Damilola Adesanya. Thank you for watching.